folks on the East Coast, and lots of people in between. Welcome. We're pleased to present today's webinar, which is Environmental Energy and Climate Justice, a conversation with Human Rights Magazine authors. This is brought to you today from the ABA section of Civil Rights and Social Justice. This webinar is part of CRSJ's commitment to highlighting and sharing updates on key civil and human rights issues through accessible public programming. As you all know, this is free. This is open to anyone. You don't have to be an ABA member. You don't have to be a lawyer. You just have to be interested in learning more. To learn more about upcoming events, which are also free and broadly available, and any on-demand programming or other resources, visit americanbar.org/CRSJ. Our website is user-friendly and provides archived issues of the Human Rights Magazine that we encourage you to look at. This particular webinar explores current issues regarding environmental justice, including updates to these authors' articles. What's interesting about being on the board of the Human Rights Magazine, and by the way, my name is Francine Lipman. I am the chair of the editorial board of the Human Rights Magazine, and I'm delighted to be with you, especially because what we're trying to do is make this magazine come alive, not just visually on our website, and it's readily available. You can download individual articles and or get a hard copy of the issue. And if you look behind Senator Dina Neal, you can see the wonderful cover. One of the things we love about the Human Rights Magazine, it's not just words from the experts across the globe, but it's pictures that'll capture your heart and your mind and your soul. This particular webinar, which is about the Human Rights Magazine, it was a double issue that we produced earlier in the year. This issue has a myriad of different articles, and today we've invited authors on just a few of the articles, so there's many more to read. We're going to talk about Nevada's historically Black Windsor Park and relocation efforts because of environmental injustice that occurred in that community. And we're going to hear it from the senator in Nevada who literally was in the room with these homeowners who were suffering this injustice and worked hand in glove to make a difference in their lives through the laws in the state of Nevada, not only changing the sense of community in that community and giving them a voice, but also, more importantly, providing financial resources. We're also going to talk about the Apache Tribe member Oak Flat litigation, California's proactive regulations, and racial conscious state actions. And most importantly, especially now, eradicating environmental racism. Our panel of expert authors are going to share their ideas with you and with each other. And if you have any questions, please don't hesitate to use the Q&A. The chat is for you just to open up and ask, interact with each other, but your question should actually go in the Q&A. Our panelists, which are not only panelists today, but also authors, and their articles are going to be put in the chat, I believe, for you. First, we have the chair of the Environmental Justice Committee, Sabrina Ashian. She is also an environmental justice advisor, of the Environment, Energy, and Resource section. She also just recently won the Advancement of Women Award for 2025 in the Los Angeles Armenian Women's Bar Association. So congratulations, Sabrina. We also have Professor Josh McDaniel. He's an assistant clinical professor of law and director of the Religious Freedom Clinic at the Harvard Law School. Talk about 6 degrees of separation. He clerked for Judge Cormac Carney in the United States District Court, a judge that I worked with when he was a partner at a law firm, and he also clerked for Judge Bybee of the Ninth Circuit. Nevada State Senator Dina Neal, a phenomenal force in North Las Vegas. We're delighted to have her article talking about this Windsor Park relocation. In addition, Dina facilitated Nevada becoming the 11th state to pass the Crown Act. And I wanted to give her a shout out because Wendy Green, who's affiliated deeply with ABA civil rights and social justice, she was kind of the genius behind pushing this out from sea to shining sea. And last but certainly not least, our panelist, Ode Salim. He's the director of Environmental Law and Sustainability Clinic, the co-director of the Environmental and Energy Law program at the University of Michigan Law School. He's also an attorney with the National Wildlife Federation, and he has a graduate degree in law, an LLM in environmental law from Lewis and Clark School of Law. So any law students or future law students out there who are focused on environmental justice, you can get a law degree and then a master's of law on the subject. And my incredible member of the editorial board of the Human Rights magazine, and specifically the issue editor for this double issue, Emily Bergeon. She is, in addition to being an editorial board member, she's also an associate professor in the Department of Historic Preservation at the University of Kentucky. She's a vice chair of the Environmental Justice Committee, and she has worked tirelessly on behalf of her colleagues at the university. A few housekeeping notes before we begin. Again, please submit your questions using the Q&A function, not the chat, but you can use the chat if you want to give shout outs to each other. If you don't see the Zoom controls, move your mouse or tap the screen down to the bottom, then they should magically appear. This program is not for CLE credit. It is being live streamed on the CRSJ YouTube channel. You can watch this immediately after the conclusion of today's program, and a recording of this webinar is going to be available and posted online at the ABA Civil Rights and Social Justice website. Please share it broadly with any and all interested people. I am going to turn my camera off and kick the ball, I guess we're saying football now, to Emily. Take it away.
Thank you, Francine, for your kind introductions of everyone here, to Allie and Melissa also from ABA, and certainly to all of our panelists and those in attendance for being here today. I wanted to start off the conversation here by hearing from each of the authors to give us a brief overview of their article and certainly any updates that have occurred since the issue was published. I'm sure there are lots of updates to provide, but if we could go in alphabetical order and start with Sabrina, that would be wonderful. Thank you.
Sure. Hi, everyone. Thank you so much for being here today. And thank you to the ABA for putting on this excellent conversation. I'm really looking forward to hearing from all of my colleagues. So I wrote an article for this issue that was on issues at the intersection of ESG and corporate responsibility. And it was in relation to California's, at the time, recent corporate climate accountability, which was about 2 years ago this all started. So I'll give a little very quick background just about what the laws are and the updates that have happened, and then answer the any follow-up questions. So California enacted Senate Bill 253 and 261, which require large corporations to disclose greenhouse gas emissions and climate-related financial risks. This was the first in the nation law of its kind. The bills together were called the Climate-Related Financial Risk Act, and they were signed by Governor Newsom in October of 2023. The purpose behind those was to increase transparency and accountability of the climate impact by large corporations. And so it was really an effort to disclose what is really taking place with corporations with regard to climate activity, their carbon footprint, their greenhouse gas emissions, as well as any sort of mitigation efforts they're taking. And if there are real mitigation efforts or just greenwashing, which we can go into later. And so the idea behind it is that investors, consumers can all have this information. It's tangible. It's information that they can utilize to determine what corporations they want to invest in or shop with. Since then, as you would imagine, there were lawsuits that challenged the validity of the act. A federal judge recently dismissed the request to halt the implementation, which means that is going forward. There was additional legislation that just laid out the timeline a little bit more clearly for California. And CARB, which is the California Air Resources Board, is the board that's overseeing this implementation. They held public workshops, and then last month they issued a draft checklist, which provides guidance for these large-scale corporations. So I think I'll stop there, and happy to take questions and chat offline with anyone. Thanks, Emily.
Thanks, Sabrina. Josh, could you go over your work and updates as well?
Yeah, absolutely. So thanks for having me. It's a delight to be on this panel. Now, I'm a bit of a fish out of water here, as the piece I wrote about isn't about environmental justice through the framework of environmental laws, but instead, what I'd like to talk about is a case that raises what I think is a fascinating question of whether environmentally sensitive land can be protected as a matter of religious freedom. And in particular, I'd like to talk about Oak Flat, also known by the Apache people as Chichil Bildago, which is in central Arizona in the Tonto National Forest. Oak Flat is a site of incalculable spiritual importance to the Western Apache people. It is where they perform some of their most sacred rituals, including sunrise ceremonies, sweat lodge ceremonies, coming of age ceremonies for their young women. Some liken it to Mount Sinai for Jews. It's really kind of a center of the spiritual universe for this people, and it's believed to be a direct conduit to their creator. So an enormously important piece of land for religious reasons. But at the same time, the area is also has immense environmental importance as well. It's home to majestic rock formations, old-growth emery oaks, rich ecological diversity, including a number of endangered plant and animal species. And the problem here, though, is that in a midnight rider and to a defense funding bill passed in 2014, Congress decided to transfer this land, which was previously owned by the federal government, to an international mining company that had plans to excavate a large copper ore deposit worth potentially billions of dollars under the site of Oak Flat. And in order to access the ore, the mining company plans to essentially decimate Oak Flat, leaving a 2-mile wide crater in its place, completely obliterating it. So a coalition of Apache Tribe members and others formed a group called Apache Stronghold and sued in federal court to stop the transfer and destruction of the land. The case has gone on for years, and they brought, very interestingly, a mix of claims. Some of their claims were religious freedom claims under the First Amendment and under the Religious Freedom Restoration Act, but they also brought claims under environmental protection laws, as well as historic preservation laws. And the case went to the Ninth Circuit, which, at least at this stage thus far, has focused on the religious freedom issues in the case. It resulted in first a panel decision, and then it went en banc, and there was a decision that was over 200 pages long where the court split 6-5 on the en banc court, sharply dividing about how to handle this question. And most recently, where my clinic has really been involved, is that we filed amicus briefs both in the Ninth Circuit and also in support of certiorari in the Supreme Court. And the update there is that, very unfortunately, in May, the court refused to take Apache Stronghold's case and declined certiorari. And you had Justice Gorsuch and Justice Thomas writing a dissent from the court's denial. And they wrote that the court's decision to not take the case onto their docket without a full airing was a grievous mistake, one with consequences that threaten to reverberate for generations. Not at this point, not all hope is lost. Although the court has declined to take up the case, because the Ninth Circuit addressed only some of the issues in the case, the rest of the case is now continuing on in federal district court in Arizona. But that's essentially the latest on that. And maybe I'll pause there, and happy to discuss further as we keep the conversation going.
Thank you, Josh. Senator Neal, could you speak to your article and updates?
Yes. Good morning, everyone. So grateful to be on this panel of esteemed authors across the nation. So my article in this journal was very personal. I was carrying the past forward, dealing with segregation and housing injustice. And I took on a neighborhood called Windsor Park that had been sinking for 30 years due to subsidence and groundwater removal. And there were 93 families that I got into this battle over. And it was a very interesting journey that started in 2019. And, you know, you always talk about how can strange bedfellows find their way together. I was able to get into this fight because of the power of storytelling, because I was fighting my own city. I don't know if anybody's ever experienced this, where you're like, it's a David and Goliath type of experience. And you're like, I'm going forward, I'm outnumbered, but I'm going to keep going because I believe in this issue. And I had gotten to a point where I needed help. And I actually went to UNLV Film School, and the students did a documentary on these families that allowed me to use that documentary for legislation, which was SB 450 in 2023, which then allowed for the entire state to hear and understand this story and know this story. And I was able to move legislation that remedied the inequity and brought back $37 million in order to relocate the families, build them a new home. It also took on, the legislation took on 45 homes, which were a part of the city's, I would say, the movement of the original families where they put them in, how can I say, I wouldn't say it was unsound housing, but it wasn't equitable housing that helped to move the families forward. So, because originally the families represented 245 families and 93 were left over. And then there were 45 families where the city of North Las Vegas built homes, and they're like the paint was peeling in a year. The doors were on the wrong side. I don't know if you've ever been in a place where you're like, you come out of your front house and your door is facing another person's door. And typically they're supposed to be facing this way. And so I also included those 45 families in the relief in that bill. And it was, let's just say it was a major fight. The city came hard for me during the legislative session. They threw out everything they could possibly do in order to defeat the measure. And but I won at the end because my legislative colleagues believed in the story that was told by the film school at UNLV. And because of that story and because of that documentary, we went from local news to CNN to Associated Press, and then ultimately to the ABA Journal on Human Rights. And we were able to tell this story. And currently, after from 23 to 25, we have been in permitting. I don't, it's more of a permitting delay, but we were able to get our permits 2 months ago. We have started construction and started to grade the land for the families, and the families are so excited. They've selected their lot, their home design, and they are not really there. It's hard for them to believe that 5 years later we were able to make this impact and make this imprint. But if you've ever had to build hope in a community, harness it, develop it, keep it, and then hold a group together, this is one of those projects where I learned that trait and learned that skill set on how do I move and maintain a community to believe that an impossible thing is actually possible. And that is what this story in the journal represents, is the long 5-year journey and the obstacles and the hindrances and all of the Goliath that tried to defeat us. And that's what that story represents, because it was a major outcome that I literally entered in just because I believed fiercely in people. I believed in justice, and I believed that no matter what, I was going to change the outcome, no matter who fought against them and who fought against us. And so I look forward to having this conversation on remedying segregation and the policies that really restrict families from getting generational wealth.
Thank you so much for that explanation and update. And I think the sort of Goliath narrative is one that everyone on this panel is going to discuss at some point. So thank you. O'Day, if you could give us an update and explanation.
Sure thing. The Supreme Court in 2023 decided a case called Students for Fair Admission versus Harvard. This was a case specifically about the extent to which universities, colleges, et cetera, could consider race as a factor in its student admissions decisions. That case is on a sort of continuum. There were a number of cases before it, including one that impacted my law school over a decade ago called Grutter. But there are these cases that are about the extent to which higher education institutions can consider race as a factor in admissions. And then those cases are part of an even larger set of cases that are about the extent to which any government entity can use race as a factor, let's say in contracting or in hiring or in grant making, or in this case, in admissions. And I started getting emails and phone calls from journalists, from environmental justice advocates, and from others asking me if I knew whether the most recent Supreme Court case would have a significant impact on environmental justice policies, in particular, federal, state and local policies that were, using race and ethnicity and national origin or English proficiency as, a main factor. So what my, article does is, after summarizing this line of cases about race-conscious policymaking and whether it could withstand constitutional scrutiny, I turn my attention to the different categories of environmental justice law that exist. There are attorneys general who are trying to prioritize environmental justice communities when it comes to the enforcement of any law, but particularly environmental laws. There are agencies that are trying to make decisions about whether to issue permits, and they're trying to figure out the extent to which they can focus on the race or ethnicity or English proficiency of a community that would be impacted by a permit. There are all kinds of instances of government entities giving money, right? Giving money to rehabilitate certain communities, the environment, the natural resources of certain communities. And the question is, can you prioritize overburdened communities, by accounting for race, ethnicity, etc. So there are all kinds of ways in which environmental justice laws, in one way or another, use this as a factor. And so when I wrote the article, the big question was, if anything ever gets to the Supreme Court, regarding environmental justice, or even just the federal, district, and circuit level courts, um, would those policies withstand judicial scrutiny? I guess the big update since I wrote my article is that in addition to the threat of a court potentially, knocking down one of these policies, there's now an additional risk that the federal executive branch will take significant action. It used to be the case, for example, that certain federal administrations, this was not their thing. Environmental justice was not their thing. They weren't going to, do much to advance it, but they were just going to kind of let it happen, if states and local governments wanted it to happen. They just weren't necessarily going to get in its way actively. I think right now the question is, would the federal government now consider actively getting in the way of those state and local environmental justice efforts? For example, could a community complain that, hey, when the government was considering a permit in my community, we did not get extra time to comment on it. We did not have certain mitigation factors apply to the permit, but in that community, over there, they did have extra time. They did have extra mitigation factors getting applied to the permit. And we think the only difference between us is that, our community is not a majority minority community, and that one is. If complaints like this come up, and those complaints have existed for a long time, but the question is, if they come up now, will the current federal administration take action? Will they, revoke grants? Will they get involved and investigate state agencies and local agencies that engage in this kind of, otherwise, for many years now, very widely accepted, environmental justice practice? So that's what the article is about, and I think that's kind of the big update that I, of course, didn't get a chance to address because of the publication date of the article.
Thank you, O'Day. I think that now I'm going to go through and pose a question to each of the authors about their articles. And as Francine mentioned earlier, if anyone has a question for the Q&A or any of the authors would like to comment, please feel free to do so. So Sabrina, your piece highlights California's leadership in corporate climate accountability. How do you see that regulatory framework influencing other states or federal or even global standards on ESG and environmental justice generally?
Yeah, so I think that it is since it was the first in the nation, it is a good precedent or a good framework that others can use and utilize in their corporate disclosure in the corporate disclosure space. There are other states that are now in the process of writing legislation or considering legislation that are utilizing California's standards and the way that California came about developing this legislation to influence their pending legislation. So states including New York, New Jersey, Illinois, Colorado. Anybody else on the panel, if you know of another one, please let me know. But it's exciting to see that happening. And I think that there's the combination of corporations having to provide this disclosure and having to provide this information and this transparency. So that's sort of leading the way that as they're doing it, then it becomes easier for states and other nations to then ask for this material information. And it's also helpful to have this framework and this precedent for other states and I think other nations to actually utilize as well when they're trying to understand their greenhouse gas emissions and their impact on the climate and on the communities that live in those regions.
Thank you. Josh, you talk about the intersection of religious freedom and indigenous environmental protection in your piece. How can these types of claims you think that are rooted in religious freedom reshape environmental law more broadly? I mean, you discussed using religious freedom and environmental protection and even historic preservation. Do you see some kind of legal recognition of sacred sites like Oak Flat as a potential model for protecting other ecosystems beyond those in an indigenous context?
Yeah, well, what I think is so interesting about cases like Oak Flat is that it brings together advocates from across areas of law, different disciplines, where there's an alignment of interest. The alignment is particularly poignant in cases like this, where the indigenous people share a special and spiritual connection to the land as land, where there's an overlap between their religious interests in worshiping and their religious interests in preserving the land, the plants, the trees, the entire ecosystem. And I think that brings up the possibility that you can, with that alignment of interests, the pursuing the means of religious freedom, which I think part of the reason for doing that is that we have fairly strong, robust protections for religious freedom on the books, in particular with respect to the federal government. Congress has passed a law called the Religious Freedom Restoration Act that essentially requires strict scrutiny review by the courts whenever the government substantially burdens religious beliefs or practices. So what you're able to do in a case like this is you're able to bring to bear those very robust protective standards in a case that, when it comes down to it, is about land that is environmentally very precious and very important. And what you could also see is if one of the potential outcomes in a case like this is that you could have Congress coming in and deciding to protect the land and to do something, and it might be motivated, at least in part, on religious freedom for religious freedom reasons, but that may be what ends up protecting the land and securing it from being devastated.
Thank you for that. It's very interesting you talk about sort of the broad umbrella of stakeholders and alignment of interests, and that is again another common theme in everyone's work is that intersection of everyone in law and thank you for that explanation. Senator Neal, your article traces about how discriminatory housing policies created long-term environmental and social injustices. How do you think present-day housing and land use policy undo these types of layered harms?
That is a great question. I think one of the first places that we need to consider when we're trying to undo these harms. I think it starts with curriculum of urban planners. Like when they go in and get their degree, what exactly are they being taught around equity, inclusion, and diversity policy? I also think that when we talk about planning, we need to be considering and making sure that past patterns and practice of segregation are also a part of the conversation. And we need to have the ability to map institutionalized inequities that happen to arise in neighborhoods, right? We all live in a city where we can drive to a certain part of town and we can say that area has been exactly the same for 30 years. And the question is always why? Why does it remain in that particular condition? Why does it remain in that state? And it's not always, the property tax. It's not always economics. It actually is more of political will sometimes. And how are you making a decision to include those communities in your plan? Talk about the distressed communities. Talk about how you're going to leverage and move those communities forward along with new growth. And typically, I don't know what's happening in other people's cities, but most cities don't want to take on the hard work of the remedy, right? And so that's why I say, if we teach students to come out in a particular, with a particular framework, a particular mindset, then when they become the urban planner, when they work with the civil engineer, right, they're going to start driving those policies and those conversations forward within the lower level of the city planning and government, so it can rise to the top, to the elected official who has to vote. I also believe that the legislature and the law plays a role in dictating, I think, policy and framework around what cities should do if we expect to see that level of change, right? I mean, because there's a level of autonomy that state legislatures have outside of the federal government in order to dictate behavior if you're within that, we're at a Dillon's rule state, so it's top down, it's not bottom up. But even in the conversations where states have where the local control is a little bit more advanced, and sometimes it's the legislatures asking permission to the county commission, can I do something? I still think it's a topic that the legislature can bring up and put on the table for local jurisdictions to discuss and at least say, this is something that as a state we're going to mandate as a behavior, because all boats should rise. And we should never have a conversation where we have invisible communities that are suffering from housing injustice and environmental issues that are affecting them.
Emily, I'm going to interrupt here for a minute because I know Senator Neal brought this community to the table. And so this community really felt, even though they had been suffering this discrimination and oppression that was literally undermining their day-to-day well-being, they didn't feel like they had a voice. And Senator Neal somewhat stumbled on the issue because of a wall, wasn't it? Or tell
Yeah.
a story about how this all came about. Was just listening to people and giving them a voice and bringing them to the table so they're not on the menu.
Thank you for that. Thank you for that. And so literally, Pastor Miller, I got involved because they were fighting over a brick wall. He wanted to repair a brick wall and the city wouldn't allow him to do it. And after I got involved, we stumbled upon the fact that there had been an ordinance since, I believe it was 1998, that pretty much barred the families from repairing and doing any kind of changes to their home. Now, this was after 1989, where they found out that the water was causing the subsidence, the streets cracking, and everything else. but they didn't know that there had been an ordinance in 2019 that basically prevented them. And the city was saying it didn't exist. And then I went digging around and then found the ordinance and said, this is exactly what's preventing him from repairing his brick wall. So although, you know, his house was slanted, he wanted to try to maintain some level of, you know, decorum with his house and decor. And so that is what drug us into this conversation with the city and debate, mainly because they wouldn't acknowledge that an ordinance was actually in place, even though we had documentation that it existed and was preventing them from doing anything for their houses. And then we were able to drag up legislative minutes and historical minutes from the city council for like 25 years that proved and established that, you know, their home insurance had been arbitrarily canceled once the word got out that these houses were sinking, and they were literally left with no remedy. So the only place that a remedy could come from was either kind of come from the city, which was refusing to provide one, or it was going to come from the legislature. And so that really, I don't know, I dug in my heels at that point. I couldn't undig them. And then I went with a stack of papers. That's within in the documentary. I went to Boyd Law School because I said, can we sue? I need someone to help me. Do we have any kind of statute of limitations that allows us to sue? No, I know that we still have some of the leftover money that the city is holding on to from the remedy in the early 90s. Can we tie it back to these dollars that they got from the federal government saying that they never completed the remedy? They haven't fixed it. And they were like, no, that's a long shot. And that's what drove me to bring the legislation to say that no matter what, I'm going to fix this problem and I'm just going to fight for these families.
Thank you. Sorry for the interruption.
Absolutely no problem, Francine. That conversation on sort of bringing the community to the table makes me think of, with Josh's piece, so much of what cases, sacred site cases is, and indigenous land rights and environmental cases are an issue of consultation and whether proper consultation has gone on. So it's sort of it's a discussion at a different level. But is there anything that you could add on that, Josh?
Yeah, I think what bringing in the religious freedom and the environmental law components of this together, I think it gives you more tools in your kit to try and address this, and whether that be consultation or invoking kind of procedural levers that can be invoked, or the substantive rights of various protective laws. I think it just expands what you're able to invoke for the protection of what you care about.
Thank you. And Francine, if you don't have a seat at the table, you're probably on the menu is one of my favorites. So thank you for using that. O'Day, in your article, you raised concerns about legal vulnerabilities of race-based environmental justice policies. Given the recent rulings on state action, what strategies should advocates and policymakers pursue to protect this framework from being just dismantled?
Yeah, so as I try to do in the article, I think there's a range of vulnerabilities. So on the low end of vulnerability, for example, I don't think state attorneys general have anything to worry about when it comes to prioritizing environmental justice communities for civil enforcement of environmental laws, right? So if an attorney general decides we've got a lot of potential cases that we could bring against people who are violating their permits or otherwise, committing violations of environmental law, we can't bring all of them. We have to exercise our judgment about where we prosecute, where we don't. That's very traditional discretion that an attorney general has, and I don't think that would be disturbed. There's some good case law, I think, protecting that. So that's on the low end of vulnerability. I think on the higher end of vulnerability, a lot of the way that these kind of state environmental justice laws work is they define a community, typically using words like, vulnerable or overburdened community. And then they say, well, if you're a community that's overburdened, we don't want to add to your burden. So if there are, already toxic and environmental stressors, if there are other reasons why your community is overburdened, maybe it's income, household income, etc., we don't want to burden it any further. And by the way, there's science behind this. It's not that they're just making a political argument or distinction. There's public health science that tells us if you have other stressors in the community, adding yet another one is not going to produce a good public health outcome. And after all, these environmental laws at the end of the day are about achieving good public health outcomes. So they typically start by defining a community as overburdened, and then the question becomes, what are the criteria or characteristics of an overburdened community? And so these laws may say something like, well, you're an overburdened community if you show up on, an environmental justice, map index, like EJ Screen, for example. And maybe that's some combination of proximity to toxic sites or household income, averages in your census tract. Or sometimes it's defined as if your community is composed of, 40% or more people who are minority, or 30% or more of people who have limited English proficiency. Now, that in and of itself, may not, lead to vulnerability, but in some of these laws, what happens is you get extra long public comment periods to reflect the fact that these communities struggle the most the individuals in those communities may work multiple jobs, they may work different kinds of hours, they may not be available for traditional public hearings. And so the idea is let's provide them more time so that we can make sure that they're participating as much as everybody else can participate. And then there may also be requirements that an industrial facility has to achieve better, environmental standards when it gets a permit. It may have to engage in certain mitigation measures, or it may have to operate further from the community than it would otherwise like to. And again, the idea there is, well, that makes sense because it's already an overburdened community. And by the way, why do we think that race or limited English proficiency might be a really good indicator for whether a community is overburdened? And a lot of this has to do with the redlining that took place in the first half of the 20th century, where we had entire neighborhoods within cities off limits to investment and grants and bank loans, and no new housing could go there, but of course industrial development and all kinds of industrial activities could go there instead. And there are some great scholars out there who have compared redlined neighborhoods to neighborhoods today. And of course, if you today live in a redlined neighborhood, excuse me, a historically redlined neighborhood, then you're likely to be a member of an overburdened community, and there's a good chance that that community will be a majority minority community. So the point is, there's good reason to think that there's a lot of science and statistics, etc., to establish objectively that we should take better care of these overburdened communities when we make policy choices about where our industrial and other environmental externalities should go. But I think those are the most, vulnerable. And so one idea for addressing that vulnerability is to essentially get rid of any indicator or criterion that has anything to do with race, ethnicity, or English proficiency. No one in the environmental justice community thinks that's a great idea on principle. When it comes to values and principle and philosophy, the whole point, is to address historical injustices. And those historical injustices were done often to communities based on their color, or national origin. After all, that's why the Civil Rights Act of 1964 prohibits discrimination based on color, national origin, etc. But I suppose that communities that wanted to really think through, we just want to get through the next many years. We just want to, have resilient policies. We don't want them coming under attack, or we want to really minimize what kind of attack they come under. They could remove those kinds of criteria and have in their place criteria related, probably to income status or proximity to toxic sites, or maybe if there's some kind of cumulative impacts assessment, the ambient air and water quality in the area, and the worse it is, the more we don't want to add, additional pollutants to that area. So if those were the criteria or factors, then I do think that they would reduce vulnerability to legal challenge. That's purely, right, like a lawyer talking about legal risk, and not somebody talking about addressing historical injustices and seeking restorative justice and doing right by our, historically disadvantaged communities. Not addressing any of that, just from a pure legal risk perspective. That is what they could do. It's to many people distasteful, to have to do that. But in some instances, it may be the difference between whether a law survives judicial scrutiny or not.
What do you do? Well, thanks, O'Day. What do you do? I'm thinking of EJ Screen. That is a tool that many of us used up until recently. What do you do to, find that information, that data, that support? There is a lot of research on, redlining and urban tree canopies, or temperatures and things like that still exist, out in academic literature and in not a nonprofit arena. But how do you find that information? How do you find that data if you're trying to make those types of arguments?
Yeah, this is a big question right now. Is when sometimes it's the case that science begins and is housed within the federal government mainly, and that, sub-federal units, states, local governments, et cetera, rely on, what's there at the federal level. But in this instance, thankfully, we have CalScreen, we have screening tool in Michigan, we have screening tools in other states. Many states looked at EJ Screen at the federal level and decided, wonderful, such a great start, let's do better. And so you actually have state-based screening tools that are quite good. And in some instances, even better than the federal screening tool, because they were premised on the federal screening tool isn't doing enough, and it's not maybe accounting for the specific unique features of our state. Maybe there's a state that has a lot of federal public land, and that's not being accounted for. Maybe it's a state that's incredibly small and has a certain, form of, local governance, and that's not being accounted for. So you've got screening tools in other states that people can absolutely look to. And again, the question is, once you have that screening tool, how do you want to define overburdened community with the data that you receive from the screening tool? And these screening tools are robust. They have more and more and more layers as the years go on. Many of the screening tools themselves are products of either private consulting groups or academic institutions, and so those academic institutions will have many of these data and many of these platforms. So I think the good news is there may be some other areas where, if the federal science isn't there and if the federal data are not there, then we're in trouble. But I don't think this is one of those areas. So those screening tools thankfully remain.
Thanks, O'Day. My piece is on access to nature, and I certainly engage with the Trust for Public Lands Park Serve database, which is again sort of an aggregate of all of that information that's so important. I'm going to move on to some of our group questions. First, the ABA's Blueprint for Advancing Environmental Justice talks about a whole ABA approach. So engaging with litigators and corporate counsel, law schools, and bar associations. From all of your views, what steps can different sectors take to embed environmental justice in daily practice?
Do you want me to jump in okay, all right. Well, I think this is an excellent conversation illustrating the importance of that, interdisciplinary approach, the idea of relying on scientists and health professionals and those in the legislature and policymakers generally, and bridging all of those gaps and working together and not working in silos. I also think it's a great plug for the ABA generally about working in collaboration with those across the country who are doing this work and in various issue areas, so that we can collaborate, work together, build our knowledge base, build our resources, be able to utilize something that's best practice going on in a different region. And then within the ABA, I'm just going to make one quick plug also for in the environmental section, the SEER section, there's a coordination committee of all of the different sections, divisions, and forums that is for the purpose of bringing all of these different environmental groups together. So those who are practicing environmental law or touch on environmental law in various areas. So those who do tort law or real estate or government work. So they're in a different section. They're not in SEER, but working together and talking together about some of the issues that we're having the conversation about today. And I'll put information in the chat perhaps about that committee specifically. But I think having these conversations and working together and seeing that it really is important to be interdisciplinary when we're approaching these issues.
I'm sorry, Senator Neal, you asked to chime in on what O'Day was saying, and I just noticed that in the chat. Could you please do chime in?
No, it's fine. I guess when I was listening to what O'Day was saying about, and maybe I interpreted it wrong, about pretty much hiding factors, which I know that that's what we're doing. I know people who are literally reshaping language so that, they don't lose federal money associated with what's going on. But I think I'm more on the other side of the issue of, okay, yeah, maybe let's hide a little bit, but I'm also more in fight mode, that I don't want to hide the things that we have been fighting for not just my generation, but the generation before us, to actually get people to care about one another, to get people to actually say that tribal lands matter, poor Black communities matter, poor Latino communities matter, poor Muslim communities matter. Like, these are things that I am not ready, even under this particular administration. I'm not ready to just lay down the gauntlet and say that I'm not willing to fight for the actual language that says a city should consider these factors, because I've seen when we remove the factors, they won't do it. That if they're not mandated or told to do it, they won't put dollars towards it. Even when it comes to city funds or state funds, because they're like, well, it gives them a pass to say it's not a priority for us. And the problem is that historically, it has never been a priority, which is why we're still having this fight, which is why we have the Human Rights Journal in the first place, why we had to do a double issue to lift up stories across the nation, is because it is still necessary to engage in this work and force people to acknowledge the inequity and the segregation and the policies that have impacted communities and changed children, and have them believing that they cannot have a good life and that they don't deserve anything better than an environment that's full of toxins and poverty. And so I'm sorry, but I'm not willing to hide everything.
Thank you. Thank you. I think that your language around storytelling and making sure that we're telling these stories appropriately, be it for your affordable housing or certainly with Josh in the Oak Flats is really very central to that. And you're saying taking out a major part of that story is not doing justice to the issue. So thank you. I think that's a really important point to make. Um, I think too what Sabrina has brought up and again what everyone else has brought up is sort of this interdisciplinary or transdisciplinary work that needs to be done. And again, Senator Neal, you talked about and you spoke to me as someone that is a planning professor, educating, you know, new generations and educating, you know, planners or politicians or law students in how it is that we incorporate all of these different things into what we all do, whether that's being a, you know, a politician or a planner or an attorney or a professor. What skills and knowledge and frameworks should law schools and CLE program emphasize to prepare the next generation of environmental justice lawyers, environmental justice advocates, and community members, so we all are capable of telling the appropriate stories and in the appropriate ways?
I can jump in on that. So this is something that I've been thinking about a lot lately. I think clinics are a good model for this. And to put a plug for clinics, I think a big piece of clinics is to be teaching students about not only how to represent their clients, but how to do it effectively and how to tell these narratives. And um, partly because of the nature of our work in seeking out cases where we can bring about greater social justice and access to justice, um, they give students these opportunities to be thinking across disciplines and to be working across cultural differences and all kinds of other differences as well. And I guess the last thing I would add is that uh, I think so often we can overlook the alignment of interests that we might have in a given case where we could be partnering together and working on something where our interests align. The Oak Flat case is kind of one example where across the hallway from our clinic office is the environmental law clinic at Harvard Law School. And all the time we talk about the Apache case whenever I discuss with the clinicians across the hallway, because we share that interest and we're both of us following along on the developments of the case. But just to give another small example, our clinic also recently has been working on a project with helping um, uh, trying to ensure that there are plant-based meal options for school children as part of the National School Lunch Program. And our interest in doing that is to protect Jain and Sikh and Hindu and other children who have religious beliefs that compel their dietary choices. But we decided to partner in that case with another clinic at Harvard, the Animal Law and Policy Clinic, which wants those same remedies, that wants those same public goods, but from a different perspective of promoting animal welfare. And so I think if we're just kind of on the lookout and trying to be aware of those types of alignments and don't just have our blinders on, especially doing that within a school context where we're trying to instill these values in the students, I think that can be really helpful.
I think that the discussion of partnerships is really very interesting and important. I did some work in Syracuse on the Superfund remediation of Onondaga Lake, and one of the most important partnerships there was between the Onondaga Nation and the neighbors of Onondaga Lake, and that was two in an environmental justice community and an indigenous community working together with a really important and valuable partnership that forwarded that remediation, which was in and of itself imperfect, But because of that partnership and that catalyst effect of two groups of people working on an issue, there was more progress made than I think that there would have been in another instance. Can anyone else speak to experience or examples of similar partnerships they've seen that have worked to have that sort of additive effect?
I think I can speak to that a little bit. It's not directly, but I do believe that, for the Windsor Park community, strange bedfellows had to come together and in order to move the needle, right? There were multiple factors. So I mentioned, so the community was the central part, but I needed others who were going to help, right? And so when I utilized the film school and the students to tell the story, then went to the dean of the law school and then the assistant dean, the Guy Pindell, and then we had a professor, Fritz, who we went on this long journey of using law school students to help do community cleanup within that neighborhood. They started to do CLEs, for attorneys and students to get interested in. The dean also allowed one of the graduates, he ended up graduating, but he was one of the students who was in the program. He ended up coming back and was running just basically a side course just on Windsor Park. We leveraged media. Like, I was able to really build and create strong relationships with like 3 particular media partners that were willing to continue to tell the story and have been willing to tell the story literally for 5 years. And that was a powerful piece to how we kind of all came together. And it's kind of amazing because there's one journalist who's literally saying, when you're done building these houses is when I'm going to quit. When I'm gonna leave and I'm gonna go into the sunset. But I'm waiting until you finish this so I can tell this final story with you. And you don't realize it until you're in the middle of it, how everyone works together and how you have to keep everyone a part of the cog, because that then becomes the unit that is moving forward the individuals, right? And it's been such a powerful collection and collaboration of people that has sustained itself for 5 years. And that's pretty strong. And the community respects that. And there weren't other elected officials, but that have joined it, except for the legislature, who has continued to fight with me to say, if we need the additional money to finish it, we're going to finish it. And they have committed to me that no matter what, they're going to vote yes when this comes up for any additional money if I ever run into, trying to finish the project. And that has been the power of how one story weaved across the conscious and the moral and emotional place of several individuals and kept us connected until we finish it.
And Emily, I'll just jump in and say to what Senator Neal said, and I think you see this most often in the legislature or in policymaking at the local or state level, this grassroots coalition building, bringing people together that aren't just in your issue area, because a lot of times that issue area won't resonate to all of the legislators. But if you get, like Josh just mentioned, if you get people in the plant-based movement and you get people in the animal welfare space, and then you get people in the freedom of religion, then you're starting to build, a broader coalition, and you're starting to reach out and get into the hearts and minds of more legislators, or housing and environmental justice communities, or, when you bring together labor and environmental justice is huge, because those are often seen as so conflicting. And so I think when we can make it so that our message is more palatable to more people, then we are able to, get what we're trying to accomplish across the finish line. And so I think that's why conversations like this are so critical, and also just why these coalitions and sort of grassroots work is really important. Oh, Francine, you're on mute.
Just to give a shout out to the clinics, because I think Josh and O'Day truly do help open minds in law schools, especially law students. The way the curriculum is designed, it does tend to silo the topics. And I think law students get a false impression that property law is just a isolated practice as compared to environmental and or tax. I mean, tax is interrelated with property and environmental justice. It's all seamless. And so the clinics help look at that. I mean, intersectionality is frankly the way the law works. Isolation is not the way it works. And so the clinics, shout out to the clinics and experiential learning. It really is impactful. So thank you for what you do.
We have a question in the Q&A that I will ask. What is the specific analysis pursuant to U.S. federal law surrounding environmental protection measures that impinge on Indigenous peoples' religious rights?
So I can't speak too specifically to that, because that has not been the kind of our focus on the case, and especially as the case wound its way up. The appeals to the U.S. Supreme Court were based on the Religious Freedom Restoration Act, but I believe in terms of the environmental laws, if I'm remembering correctly, it was perhaps more kind of administrative law focused in terms of the environmental impact statements, and making sure that the federal government had kind of met all of the thresholds and passed all of the steps that it needed to take. And there were also, on top of that, treaty concerns, and there were national historic preservation, landmark type concerns that were raised as well. But I can't speak too specifically to the environmental laws.
Yeah, I'll just say briefly, I don't think it's so much that environmental laws need to avoid those kinds of conflicts with religious interests. The religious exercise legal frameworks would come into play at that point, not so much the environmental law frameworks themselves. But there are plenty of opportunities within environmental law to have indigenous rights and religious exercise rights intersect in ways that promote environmental protection. I happen to be this semester teaching a mini seminar on theology, ecology, and the law. And one of the things that we discuss is, under the Clean Water Act, for example, we have in Minnesota a really interesting water quality standard that focuses on wild rice protection, because wild rice is so crucial not only to the ability for indigenous peoples in the Northern Great Lakes to survive, but it's also a very important part of their sacred practices. And so there's actually I think it's a sulfide standard that specifically protects wild rice. And I believe in New Mexico, there's a protected water use that is related to the indigenous uses of those waters, ablution related uses and others, and to protect the water quality there so that it can be used for their sacred rites and rituals. So there are opportunities within environmental law to affirmatively protect the indigenous religious interests by setting environmental standards that will protect them.
Thank you both. Let's see. I'm going to have a few sort of summative questions. One of them being, what do you think is left of federal environmental justice? Will we ever get back what we lost? And do we want to get back what we lost, or move forward with new frameworks?
I'll just answer this very briefly, Emily, to say, there's been a very, very significant, if not total, dismantling of federal environmental justice legal infrastructure. But what that revealed is that that infrastructure, if you even want to call it that, actually, it's probably not the best word, was really quite ephemeral. There was really nothing resilient or permanent about it. We had the executive order from 1994. We had many, federal agency, responses to that executive order. We had agency offices of external civil rights enforcement, considering civil rights grievances based on state and local environmental agencies who take federal money and were doing bad things with it. But all of that was really, a lot of that was based on the executive order. What was not based on the executive order, right? The responsibility for federal agencies to exercise civil rights oversight over state and local agencies who take federal money, and part of that would be whether there are civil rights violations related to environment, natural resources. That you didn't need an executive order for that. But those institutions are based on budgetary allocation, right? So if you gut those offices financially, I mean, from a budget perspective, then they just don't they don't exercise that oversight at all. So much at the federal level was ephemeral to begin with. There was never an environmental justice law or regulation at the federal level. You had an environmental justice executive order, and then the civil rights legislation from the 60s, before that. What the states are doing that people should be quite, proud of is they're actually passing laws. The legislatures are enacting laws. Those laws are not executive orders or gubernatorial orders that can just be ripped up by the next administration. Those are laws that are going to be there for a long time, probably, and it's going to take a massive legislative, change to ever undo those laws. And in some of the states, like New Jersey, you don't just have laws, you actually have direction for agencies to then promulgate rules. And again, not that those rules, cannot be changed later, but always more challenging once you have a law and a rule in place to undo it later. So you're seeing actually states doing things that are going to be more resilient. So I don't know that we want to go back to what we had at the federal level for environmental justice, because what we had was so incredibly fragile and ephemeral. I think if we're going to go back, if we're going to do environmental justice at the federal level, we need to do it like states are doing it now, and actually find statutory regulatory vehicles to carry environmental justice objectives.
Could you possibly, O'Day, sort of elaborate on, I mean, I know it's everything from state and local climate litigation or climate justice litigation all the way up to constitutional amendments to address issues surrounding EJ. Could you elaborate a little bit more on what states are doing, or even local governments?
Yeah, I mean, California, for example, has a really interesting law that requires comprehensive planning to incorporate, environmental justice, so that when communities are thinking about what they want to look like 10, 20, 30 years down the line, environmental justice has to be part of those comprehensive plans. And then the hope, obviously, is that land use and zoning that implements those comprehensive plans follows. You've got New Jersey and New York with absolutely landmark environmental justice laws that are defining overburdened communities, not only saying, one of the things that I say in the environmental justice course that I teach at the law school is, a lot of when people say that environmental justice is done, often what they mean is that procedural environmental justice is done, that more process is there, and there's nothing wrong with that. The problem is, when you look at the studies and the analyses, not enough procedural justice leads to distributive justice, leads to outcome justice. You don't, just because you have better processes doesn't necessarily mean you're going to end up with better results. So while it's not a bad thing to have more and better processes, that's necessary, but it's insufficient. Those state laws in New Jersey and New York are actually trying to manage outcomes. They're talking about real changes to permits, providing permit issuers the ability to revoke or reject permit applications, for environmental justice criteria. So those laws have probably given more teeth to environmental justice legislation, really, than anything else. And you mentioned a couple other examples. There are certainly examples of constitutional provisions like environmental rights amendments that already exist, but advocates and lawyers are trying to breathe sort of environmental justice life into them now. But in terms of laws that are dedicated environmental justice laws that are, intersectional, that do account for, place and the different, the moving trends in industry, I think, we can look to especially the landmark statutes passed in New York and New Jersey in the last 3 to 4 years as terrific, examples, not perfect examples, but really good examples of what a state level environmental justice framework can look like.
Senator Neal, your work was on housing justice and its intersection with environmental justice and current fights around zoning and infrastructure and climate resiliency. How do you see that progressing in those types of regulatory frameworks and advancing environmental justice?
Thank you for the question. It's something that I'm still contemplating and actually working on. I'm actually looking at legislative session in 27 and thinking about bringing an omnibus environmental law bill, different than what I've done before, to try to get at the resiliency issue, mandating the kind of behavior that I would like to see the cities and the urban planners perform. And I'm really, so I was listening to O'Day and I'm thinking I need to read New Jersey, because I was just like, maybe this is going to be like an established framework from where to go, because I'm always thinking I need to leave something in place within the law after I'm gone that another legislator can work on, they can move forward and say, no, this already exists, and I would like to build upon it and strengthen, so that, the work is half done, if not 75% done, so they're not starting from scratch. And so I'm deeply thinking about what it is that I need to do. I'm reading everything possible to try to understand how can I change not just Windsor Park, but other communities that are in distress, communities that need rehabilitation, that need a focus, but for whatever reason, no one's cared, right? For 30 years, whether or not it's urban, whether or not it's a rural community. And that's what I'm thinking about now. I'm actually developing the plan. How can I continue to fight in this space and create policy framework so that the new young leaders that come behind me have policy to work with and to move on?
And I will ask the last question of the webinar that I will give full credit to Francine for coming up with this question. What gives you hope for a better future for future generations? It's a Friday at almost 5 o'clock on the East Coast, and these are all very heavy topics. So it is. I came from a class teaching first semester freshmen about equitable access to parks and touring them around Lexington, Kentucky, where I am, to teach them about the need to have these spaces in every community in the city. And that is, watching those students become engaged in that information and participating in this is what gives me hope for environmental justice. And I'd love to hear from all of the panelists sort of what it is that is continuing to inspire you to do this difficult work.
So, Josh, you can go.
No, go for it.
No, I'm going to just say this quote because this is what I live by. So Audre Lorde had this quote that basically she said, When I dare to be powerful, to use my strength in the service of any vision, then it becomes less and less important whether or not I'm afraid. And that's how I maintain my hope. And I literally I've been reliving that quote my entire legislative career, which is 15 years. And that's how I keep going every day. That if I have the vision, then I can't be afraid to push and act, because it's not about me, it's about everyone that's coming after me.
It's so great. Um, so for me, I guess what comes to mind is the students that I work with, and just kind of thinking about the next generation. And in particular, I think one of the kind of beautiful things about the work that we do is we're working with all kinds of different students, even, not just different religious perspectives, but even different political, ideological perspectives. And they can all come together and rally around the Apache people, or rally around Oak Flat. And the students resonate to cases like this. And kind of no matter what walk of life or perspective they come from, there's kind of going back to the thought earlier about kind of these compelling narratives. I think they can really capture and motivate anybody. And I think this rising generation that we have of lawyers, I think is especially attuned to this, and is especially thinking about it. So that's one thing that gives me hope.
I think I'm hopeful about what's happening in the States. I mean, I think it was not a bad thing that there were all of these federal environmental laws passed in the 70s, and that we have this cooperative federalism backbone. But I do think that it's good that there are a lot of people thinking about how we can root so much more of environmental protection, climate change management, natural resources management, et cetera, in states. It's not easy because there are different resource limitation issues at the state level. But in terms of our federal constitutional structure and the ability for states to do these things equally with the federal government, I'm actually hopeful that we might see a maybe cooperative federalism, not necessarily in the rear view mirror entirely, but just much more robust action at the state level, with the thought in mind that there isn't always going to be a reliable federal partner, and if it's not going to be done at the state level well, then it may not get done, and so we should probably get it right at the state and local level too.
Yeah, I'll just conclude with I echo everyone's sentiments, and I think it's engaging like this is really hopeful. I think having these conversations and building bridges and finding out where we can help one another and build one another's infrastructure in the environmental justice space, I think is really exciting. And so I think there is obviously so much that we can be um, frustrated and upset and scared over. But I think there's so much that we can do and we can advocate for and we can build and we can create that policy and we can create the future that we want to see. And so I think, just trying to keep that in mind, that there's always something that we can be doing to be positive.
Amen. And thank you, O'Day, for kind of a segue into our next forthcoming issue of the Human Rights Magazine, which should be online at the end of this month, if not early November. And that is an issue on state, local, tribal, and territorial advocacy. So across all of these issues, what are these states and these local jurisdictions doing to make change, to fill the federal void? Well, let's give loud applause to our incredible panelists for sharing their insights, and to everyone who has joined us live or on demand. Your participation is what makes these conversations so impactful. And just a little shout out, we have Giving Day for the ABA Civil Rights and Social Justice, which frankly has really been hurt with this administration's cutbacks and focus. October 23rd. If you have not joined us as a member, please do. Stay connected. Help us shape the future of civil rights and human rights. We invite you to jump on our website, interact with any of these amazing scholars, read their articles, read the rest of the issue, and stay tuned. If you join us, you get 4 issues a year, and you can actually get a hard copy or online if you want to be a little bit more environmentally friendly. So thank you, each and all, and our wonderful moderator. Loud applause, and keep doing the work. Happy Friday and have a wonderful weekend.